Thank you very much. Thank you very much, Madam Speaker. Madam Speaker, I beg to move the following motion standing in my name. Whereas the Attorney General was aware of the $1.2 billion claim brought by the Petroleum Company of Trinidad and Tobago in 2013 against Mr. Malcolm Jones for the breach of his fiduciary duty as Executive Chairman in relation to the failed gas-to-liquid project, and whereas the Attorney General gave instructions to attorneys representing Petrotrin to file a notice of discontinuance, thereby bringing the legal proceedings to an end prior to the commencement of the trial, which effectively ended any independent, impartial, and judicial attempt to bring accountability and transparency to a matter involving $1.2 billion of taxpayers' money lost. And whereas information in the public domain suggests that there was no thorough assessment of the evidence prior to the decision to discontinue, and whereas, Madam Speaker, there has been a lack of due diligence and disclosure by the Attorney General concerning the discontinuance of this matter, which has fueled claims of political interference in the matter, and whereas the Attorney General has, in relation to this matter, proffered incomplete and unsung legal advice to the Parliament and the national community, and whereas the Attorney General has, as a consequence of the foregoing, conducted himself in a manner to compromise his office, be it resolved that this Honourable House express its loss of confidence in the Attorney General and call on the Prime Minister to immediately relieve him of his portfolio of Attorney General of Trinidad and Tobago. Madam Speaker, today we meet for one of the most important motions, one of the most important piece of business that a parliament could consider in modern time. Madam Speaker, I want to begin by indicating to the member for San Fernando West that we raise this motion and will debate this motion with no ill will, no malice, no hate, and no hostility to the member for San Fernando West. We are parliamentary colleagues while being opponents, and this matter is not to be taken as a personal matter against the member for San Fernando West. In fact, Madam Speaker, my colleagues and I will prove that the Attorney General gravely misconducted himself in the single, inarguably, the biggest political scandal and cover-up in this nation's history. It is the largest financial scandal in history. Twice the value of the Piarco International Airport, bigger than the Brian Lara scandal at the stadium in Taruba. And, Madam Speaker, it is equivalent to the withdrawal from the Heritage and Stabilization Fund. Madam Speaker, let us begin at the beginning, if we can. It was a warm September evening on September 9th when the member for San Fernando West excitedly sauntered onto the stage at Queen's Hall to present himself to His Excellency, oblivious of the law and protocol that the member cannot take his oath of office before his Prime Minister takes his oath of office. And so he enthusiastically recited an oath of office as this nation's Attorney General, only to be told that it was a breach of protocol and indeed law. This misstep set in train a series of mishaps, misadventures, misspeak, misfortune, and mistakes, some more important than others, that led us to this rainy day in June and led us to this journey when the House today must consider expressing its complete lack of confidence in the member for San Fernando West and Attorney General. But, Madam Speaker, we are not here today to talk about the blunders and the bungling. We are not here today to talk about all the inaccurate statements or misstatements. We are not here to talk about the incorrect assertions and downright misrepresentations, all of which cannot be accommodated under one motion. We are here to explore and reveal one of the most scandalous and bizarre developments in our post-independence history, one that has impacted upon the national economy, our flagship petroleum firm, and indeed the workers in the energy sector. Madam Speaker, I say at the beginning, this has absolutely nothing to do with who was naive and who was duped. It has nothing to do with who made a bad decision or who was a bad manager, as some would have us believe. This, I advance at this early stage, is what we call Jones 34. This is the scandal that we face. Because what they have accused the former administration of doing, they actually did on this occasion. Madam Speaker, when I read the notes and claims and court documents, all of which we are certain the Attorney General has, it is like reading an international spy thriller. It is hard to put down. It has all the ingredients of lies, deception, conspiracy, cross-border fraud, invisible power players, visible scapegoats. It is a financial thriller, a local billion-dollar shorting. Madam Speaker, sadly, it is not fiction. The Jones papers make the Panama Papers look like a comic book. It is juicy and delicious. It is about financial crime. Madam Speaker, today the government speaks about auditing NLCB. They speak about auditing a fellow who got a $300 food card. We are talking today about almost $3 billion of taxpayers' money that disappeared. Madam Speaker, if we had prevented World GTL, gas to liquids, if we had prevented that from taking place, we would not have to dip into the Heritage and Stabilization Fund today. While the money is irrecoverable, accountability is not. Accountability and transparency is required. Madam Speaker, the story, I would like to give the story in a nutshell. I will not delay the House by quoting extensively from documents which are in the possession of the Attorney General, and for which some of these documents have been the subject of newspaper reports. Madam Speaker, in beginning, I also like to remind the country, and I speak to the national community today, not necessarily or not only members opposite. Madam Speaker, almost 100 years ago in the British Parliament, 1924, the British Parliament met to consider a motion of no confidence in His Majesty's Attorney General, Sir Patrick Hastings, MP. It was moved in the British Parliament by a former Minister of Labour, Sir Robert Horne. And Madam Speaker, it was a motion relating to the institution and subsequent withdrawal of proceedings against the editor of a newspaper. Madam Speaker, what is important for me to make reference to here is not only that this led to the fall of the then government, but Sir Robert set the tone for that debate as I would like to set the tone for this debate with a compelling proposition. He said, and I quote, "If the administration of the law were to become subject to any considerations of political expediency, then justice as we know it would disappear. Civilized community can only enjoy full freedom if the political executive is excluded from interference with the mechanism of the administration of justice. The Attorney General must be entirely free of political influence whatsoever. He acts in a judicial capacity, and no minister, no political party is entitled to interfere with him. If crimes were not to be punished because the delinquents belong to a particular party, then the law would be mocked and justice destroyed." Unquote. Madam Speaker, the story of World GTL, and I will say in 10 minutes or less, the story. Every iota of data I use could be data in the possession of the Attorney General, if he was to read and consider. It was in and around March 2004 that one Professor Ken Julian met and brought World GTL to Trinidad and Tobago.
Prime Minister's advisor?
The advisor of the Prime Minister, current Prime Minister today, brought...
Member, please, no crosstalk. Continue.
Thank you very much. Dr. Julian brought World GTL to Petrotrin. They brought, Madam Speaker, in quick time a proposal for a gas-to-liquid plant, promising initially technology, patent technology, new technology, project management, and finance to complete a GTL plant in 18 months. Petrotrin rejected a proposal brought early, and I wanted this to be clear, When World GTL came here, part of their initial proposal was ownership of the gas reserves of Petrotrin. That is what they came here for, ownership of gas reserves. Petrotrin rejected that. In 1 month record time, a proposal was made to the National Gas Export Task Force, of who that task force was chaired by the same Professor Ken Julian. So Professor Julian brought them and then chaired a task force in Port of Spain. And who knows this now? Recommended the project for Petrotrin to adopt.
What?
And the email connection here is with a company called Kenneth J. I will come to that later. So by proposal comes in March. By April, proposal accepted, and in record time, memorandum of understanding is signed. 8 weeks later, Madam Speaker, as someone who have presided over about 5 mega construction projects in this country, I can tell you that process will likely take 12 months or more with due diligence on companies coming to your country. You would have to visit, you would have to look at their work, look at their industry track record and so on. I will come to that in a few minutes. Madam Speaker, they started construction before financing was in place and before engineering was complete. There was no due diligence on this firm, this entity. The technology promise never arrived. There was no feed study, no what is called front-end engineering design. No study. As early as March 2005, Petrotrin managers declared, who is World GTL Inc.? Who are the investors? Do they have finance? Do they have industry knowledge? Do they have a license for the technology promised? What provision have they made for abandonment or non-completion? But Mr. Jones carried on. The project agreement was executed in record time in September 2005. We were spending money and giving to foreign shareholders total control of our money. So Trinidad and Tobago through Petrotrin was spending all the money, but they had 49% of the entity. They had no control over an entity, but all the money coming from Petrotrin. World GTL, Madam Speaker, bullied Petrotrin to make credit advances for everything pending finalization of financing.
Bullied?
They bullied. They demanded money to buy an old methanol plant called Premco, saying that if we did not buy the plant quickly, the Chinese will take the plant. They said within hours, if we don't decide to buy, the Chinese go on with the plant. Well, Petrotrin, it went to Petrotrin again. Petrotrin officers, the record suggests, warned Mr. Jones and others that you cannot enter into that type of arrangement because somebody is bullying you to buy a plant in a few hours. Madam Speaker, the project was described as an extraordinary project with a factored estimate. Petrotrin began to give money from day one, advancing credit. The project started at $850 million and went up to $2.5 billion with 33 cost overruns.
Scandalous.
That is how the project began. Madam Speaker, at all time, World GTL was bleeding Petrotrin and bleeding the national economy. In the mix, at all material times, World GTL kept pressing Petrotrin for money. And foreigners were embarrassing local managers. Madam Speaker, I will just read one email, an email exchange. I believe it was in early February. Madam Speaker, it was in 2005, Madam Speaker, December, when Petrotrin wanted more time to consider financing these projects and shelling out and flinging money. The CEO of World GTL, one David Loring, President and CEO, he told Petrotrin, and I quote, he says, my wife has more courage than Petrotrin. My wife has more courage than Petrotrin. She wired US $200,000 to Louisiana Chemical today. At some point, Petrotrin needs to stand up shoulder to shoulder with us and get construction going on the plant. Unquote. Madam Speaker, would you believe the same day Petrotrin responded, they had more courage than his wife.
What?
They approved $24 million for World GTL.
What?
The same day. In that month of December, $60 million went in the month. Madam Speaker, World GTL made out themselves as having finance or being in a position to secure financing. When Petrotrin managers and even directors raised concern about out-of-control financial administration, wanting greater transparency and accountability, WGTL shot back. Hear this in an email, 2nd February 2006, from the same rude president and CEO. He said, "We are disturbed by Petrotrin's desire to control finance, administration, and other aspects of the project." Hear what he says. "The basic structure of the agreement is what Dr. Julian, the minister, and Mr. Jones wanted. What? Namely, for us to take full control of construction and operation of the GTL plant. We were bringing the entrepreneurial spirit to Petrotrin. Your board was just to approve the subcontractor, not to manage the terms of the contract. WDGTL is here because we have the expertise to drive the job." Unquote. That is the response of World GTL, telling Petrotrin, your job is not to micromanage and look at the terms of the contract. It's to give you the money, approve the contractor.
The minister.
And the minister, who was the minister at the time? Madam Deputy Speaker, I come to my Madam Speaker, I come to my recitals now, where I am one of my recitals here is that the Attorney General compromised himself on this matter. Right. Madam Speaker, the Minister of Energy at this time was one Dr. Lenny Krishnlal Seth.
Oh, Krishnlal?
Dr. Seth is indeed a close relative of the Attorney General of Trinidad and Tobago. As Minister of Energy, he supervised this project, gave consent to this project, and the Attorney General was therefore duty-bound to recuse and remove himself from dealing with the World GTL matter. And that, Madam Speaker, I am saying on that alone, an Attorney General in a decent, mature democracy ought to resign from office after presiding on a matter in which a close relative had care, exercised supervision and ministerial control over a project. So uncle started and nephew finish it.
What?
That is what we are suggesting. Madam Speaker, then came the oddity of an infamous joint and several completion guarantee. Unbelievably, Petrotrin agreed to provide a guarantee to Credit Suisse to guarantee a payback to World GTL. What this means, Madam Speaker, in a nutshell, is that if you guarantee through joint and several guarantee, it means that I guarantee my part, but I guarantee your part as well. So Petrotrin guaranteed a loan saying that if the other partner default as well, I will pay. That is unbelievable. We cannot find precedents to support that. But Madam Speaker, Petrotrin raised the concern, their managers, their senior staff and officers raised concern about this. In several documents at Petrotrin, senior managers called on Petrotrin to review and find an alternative financial mechanism outside of joint and several guarantee. Madam Speaker, the documents are here and they will tell you, Petrotrin, when Petrotrin was attempting this, a former board member, one Anthony Chantak, expressed deep concerns that this project was heading south with escalating project costs, market risk, and higher financial costs. Mr. Chantak, at a board meeting, also shared the view of management that they should look for alternative mechanisms for financing this project outside of a joint and several guarantee. Madam Speaker, remarkably at a board meeting on the 31st of May 2006, when board member Chantak was calling for due diligence for greater risk evaluation, the alarm went off in the middle of the meeting. Everybody walked out of the meeting. Madam Speaker, when they returned to the meeting, they all agreed to provide the guarantee. It's a phenomenal experience here. By August 2006, several committees of the board were adamant that alternative mechanisms must be found and not to do this guarantee. Mr. Jones had all of that in his possession. He knew all of that. Madam Speaker, WDGTL pressured Petrotrin again, Madam Speaker. And I want to quote from another piece of correspondence, September 7, 2006. The bottom line, they say, is that GTL project faces insolvency within a matter of days unless we close with Credit Suisse. They are saying now, the same Loring, we both knew that Petrotrin had to cover cost overruns. We both knew that. Madam Speaker, so while at the 5th of March 2004, the president of World GTL was telling Petrotrin that they are bringing finance and management and technology to the project, the same person was saying in a year and a half, we entered the relationship as a project developer. Madam Speaker, 3 human beings agreed to do a bridging loan of $60 million, Madam Speaker, at a subcommittee meeting of the board. On the same day, Mr. Jones wrote to Credit Suisse promising that Petrotrin board will approve a loan of $650 million, a project loan. Wow. 125 million United States dollars.
Wow.
Madam Speaker, Petrotrin initial investment was only supposed to be 60 million TT dollars. They were supposed to invest 60 million TT dollars. They end up guaranteeing a loan with that bizarre guarantee. For now, at that time, 125 million US dollars.
How much smoke alarm went off?
That is after the smoke alarm went off.
And how much time?
Madam Speaker, let us fast forward quickly to 2009. World GTL is placed into receivership. Petrotrin has to make good its guarantee. And they have to pay back billions, almost $3 billion paid back to Credit Suisse, who called on them to pay back when the project bust. Workers lost bonuses. There's something called variable pay. The workers in the energy sector could not get their variable pay because Petrotrin spent out the money to pay back the loan. And that could not be factored in as what is called net income. Workers lost millions and millions of dollars. That matters before the industrial court now.
Yes, yes.
Madam Deputy Speaker, let me tell you that NIB, National Insurance Board, in and around September 2006, approved an investment of $60 million to World GTL. So today they complain that somebody got a food card for $300. They want to audit them. But you cannot increase food card, you cannot increase pension from NIB, you cannot give any benefit because NIB squandered $80 million on World GTL. Madam Speaker, that money was written off. I am building the case of this mammoth financial scandal. Madam Speaker, I am advancing the point that nothing here was accidental. It was a systematic, calculated, deliberate and willful assault on the finances of Petrotrin and Trinidad and Tobago. Mr. Jones has 45 years experience in energy management. He will not do that in his private life. How will do that? How will do that leading the state sector company? The Attorney General, if he would have considered these matters and read the documents, could not in good conscience go and withdraw a matter like this before the court. Madam Speaker, NIB lost $60 million of taxpayers' money. The chairman of NIB at the time was Calder Hart. The recommendation to invest in World GTL came from the NIB Investment Committee, chaired by Calder Hart. So Calder Hart took up $60 million and put it into World GTL, and NIB today has written off that. They have written off that. Do you know Neil and Massey? Neil and Massey was working for a subcontractor, Neil and Massey Engineering. They lost $40 million. Neil and Massey. Guardian Holding, a private company. You know, they were bringing the entrepreneurial spirit, but they robbed the entrepreneurs of Trinidad and Tobago too. Guardian Holding lost $30 million on an investment in WGTL. Madam Speaker, UTT, is it UTT? I am told that UTT under Ken Julian also invested. I'm not sure of that. We'll check that. Again, Madam Speaker, they were taking a bucket and dumping money. They were pouring good money after bad money to try and reclaim lost money. That is what they were doing. And 3 people took a decision.
That sounds like a bucket, an excavator.
Madam Speaker, do you know the decision to give a guarantee of $125 million? That decision was made by a board through a wrong-robbing process. They did not, they call up everybody on the phone and say, listen, we want to guarantee $800 million to Credit Suisse. You agree or not? By phone, that the $800 million was squandered in a wrong-robbing process. Madam Speaker, the point I'm making is that Mr. Jones presided over that the information is there and the Attorney General has it. And the course would have moved and moved and moved. I want to go through that quickly, Madam Speaker, because I don't want to spend too much time. The information is there. The Attorney General, and Madam Deputy Speaker, let us come to the Attorney General and his case now. By September 2015, out comes a newly minted Attorney General related to a former Minister of Energy who presided over this matter. And the Attorney General was before a high-profile member of the PNM, the public relations officer of everything. And I am advancing the argument that the member for San Fernando West operated like the PRO of the party, not as the guardian of the public interest.
Well said. Well said.
The member for San Fernando West bowed to the dictates of the party and the energy czars. He announced on his entry to office, I will be reviewing all the matters he will be reviewing. What did he review between September to December? What did you review? It was only until February 2016, I believe in and around the 16th of February, that the Attorney General met with counsel on this matter. He had received a letter in November 30th, 2015, advising him of this from an attorney at law with a package. The Attorney General tells us elsewhere that there was no file, there was no documents, there were nothing. But yet in a letter from the very Attorney General, Madam Speaker, and that letter dated February 1st to Mr. Varun Debadine, the Attorney General attaches a list of documents, 18 documents. He says lists of documents, we have 18 of statement of case, claim form, defendant application, and so on and so on. But then tells the public we have nothing, no documents available. But if you had no documents available, what steps did you take? What steps did you take between September to February to manage this? And I want to remind the Honorable House, Madam Speaker, that in this matter, under the former administration, Cabinet took a decision that the Attorney General will manage these matters for a reason. The financial magnitude of these matters meant that if Petrotrin were to lose in arbitrations or in court, the Treasury would have to pay $2 billion. $2 billion. Also, Madam Speaker, you could not have asked Petrotrin to take lead on those issues when it is some of the same persons would have been involved in the matter in the first place in the World GTL. So you could not have asked Petrotrin to take the lead. Cabinet decision was that the Attorney General take the lead, handle it with the care, skill, diligence. That has not been changed to our knowledge. But Petrotrin also did a resolution of the board to give care to the Attorney General. So that today I ask the Attorney General whether or not the Petrotrin board has taken any steps to revoke that resolution. Because if they did not, it means this Attorney General has custody of the matter, has to provide the skill, the diligence, and the care of the matter. But what care did he provide, Madam Speaker? What care? Met on the 16th with the lawyers, in which an opinion came to him. The Attorney General said it was the first time he received an opinion from one Mr. Nelson. That opinion is dated October 11, 2015. So the first day the Attorney General gets it in his hand, February 16, 2016. But the opinion is dated October 11th. What did you do? They spent time liming, gallerying, driving through San Fernando, hanging out from the side of a van. They spent time doing that, but not time doing the hard work of the ministry. But Madam Speaker, how could an opinion dated October 11th come to an Attorney General in the next year, February 16th? Remarkably, Petrotrin board now meets within 48 hours at a hurriedly assembled meeting of Petrotrin board. They take a decision to withdraw the matter from the court. Now, they did in 48 hours, no consideration. The Attorney General will not call upon Mr. Russell Martineau, Senior Counsel, or any other legal light to give a second opinion. And that opinion was based on an issue of disclosure. Madam Speaker, I could put it to you in this language. If any member opposite or if any citizen goes to a doctor, God forbid, and the doctor say, look, bad news for you, we did the blood test and so on. It looked like cancer. What do? Lie down on the operation theater one time? You rush into the operation theater and say, look, cut off what you have to cut off. No. Due diligence, you will get a second opinion, do over the blood test. You might even go abroad and do that. You would want a second and a third opinion. You want to tell me that on February 16, the Attorney General met with the council on this matter, and 48 hours later, Petrotrin withdraws the matter. And then the Attorney General claims, I had nothing to do with it, that is Petrotrin. That is Petrotrin. But at that meeting, they referred the opinion, and that part of the opinion, to Petrotrin. So the Attorney General cannot tell us that he had nothing to do with it. This was Petrotrin business. No, no, no. As Attorney General, you had the care of a $3 billion matter. Then the Prime Minister comes back from one of his many trips abroad. He came back from his 10th trip abroad. In the airport, he said, that had nothing to do with me or the cabinet, it's Petrotrin. So the Prime Minister takes the same approach. This is a Prime Minister who chastened down the Parliament for $30,000. He wants the money.
Want the money right now.
So this Prime Minister is concerned with $30,000. Quarreling on a public platform for $30,000. Take a hands-off approach. It's not me. The cabinet didn't take no decision. That is Petrotrin. Who put the Petrotrin board? They are political appointees. It is you. Madam Speaker, that resolution of the board where they decided is another amazing matter. The chairman recused himself. You don't know who chaired the meeting. You don't know whether a note was prepared on this matter. Was a note prepared? Was it sent to members of the board? Did they have time to consider? Did they wrong Robin on that as well? They're giving everybody named Robin a bad name. Huh? And Madam Speaker, that meeting, Madam Speaker, is under a cloud of confusion, is in fog, that meeting, where they decided immediately to withdraw the matter. Madam Speaker, I don't want to read at length, Madam Speaker, from newspapers and so on, but the Express responded, Mr. Jones win, but TNT loses. It is hard to swallow the reality that state-owned Petrotrin was taken for a $1.2 billion ride by foreign smart men. Express again, law applied to some. J2UM, drop cases against union members too. Newsday, most unsatisfactory. I don't want to delay the House by reading these matters, Madam Speaker, reading in detail. But what I want to indicate that Petrotrin acted on the advice-prodding influence of the Attorney General and the government of Trinidad and Tobago. Madam Speaker, they claim, and you know, when we ask the Attorney General to tell us about this in the public domain, what do we get? Madam Speaker, you know, I want to just tell you, I spent some time reading a book called In and Out of Politics, Tales of the Government of Dr. Eric Williams. Madam Speaker, at page 97, Winston Mahabir is the author, a former government minister of the PNM. This is good history. I think the member for Arima was on the compound then. And he says here, listen to this one. Winston Mahabir says, we invented in government a term. We invented a term in government. It was called to sucaranize. To sucaranize was to do what only Lionel Frank Sucaran could. Talk on every subject with an air of authority. Talk for as long as possible with the maximum repetitiveness and minimum content. Bore everyone to distraction without boring a hole in any argument. Madam Speaker, it was to use a pseudo-smooth approach. Keep talking in the hope of the immortality by volume. Unquote. Madam Speaker, I hope we will not have a response that will just be to succeranize on the issue, Madam Speaker. And Madam Speaker, what has the Attorney General told us? He told us that it was wrong for the former Attorney General, Madam Speaker, to take control, care, and close supervision of this matter. What was wrong about that? We had to take control of it, and I explained the reasons why before. The Attorney General told us that one attorney did not hand over files, witness statements, and so on. That attorney wrote a letter to the Attorney General as well, dated, I believe it was around the 1st, 2nd of February this year. 2nd of February, where the attorney is at pains to point out that I did pass documents to the Attorney General on the 30th of November last year. Do you know, Madam Speaker, that attorney gives out here about 5 examples of trying to meet with the Attorney General, chasing him down. In one case, he said, when you never responded to my phone calls and I talked to your friends, I even met some of your friends, the member for Port of Spain North, on January 23rd at the Cancer Fete in San Fernando, in which I asked him to please contact the Attorney General. We have to talk about the World GTL matter at court. So the lawyers were at pains to chase down the Attorney General on this matter. They did not leave it. And why did the Attorney General leave it until the matter was coming up at the court? Why? Was it political influence? Was it a plan to remove Malcolm Jones from the court? Because, Madam Speaker, the Attorney General did something else that is inappropriate and compromised his position. And that is why he could not give the correct assessment of this matter. Far apart from his lack of care, his lack of interest, his lack of consideration on this matter, the Attorney General, to our knowledge, sat in a meeting of cabinet that approved Malcolm Jones on October 8th as a member of the subcommittee, the Energy Subcommittee. Did the Attorney General tell the government, I cannot participate in that because I have the care of a matter in which Mr. Jones is the defendant? Did the Attorney General tell his government that I have to advise you that we ought not to appoint this man? He's before the court on a $2 billion matter. But by appointing Malcolm Jones to the Energy Subcommittee, you have prejudiced this matter. Okay. You have pre-tried this matter. You are saying he's innocent. And the Attorney General ought not to have been a part of that cabinet decision. And that is what they did, Madam Speaker. They appointed him. They appointed Mr. Ken Julian, whose name is called in this as well, as advisor to the Prime Minister on energy matters. Madam Speaker, the same players from 2004, 2005, it is like a serial. The same characters are back. No wonder Mr. Jones said in a report in The Guardian, he said, if I had to do it over again, I will do it over again. Wow. And yes, we believe that they are doing it over again. They are doing it over again. So the Attorney General ought to recuse himself. He may have allowed the member for Port of Spain North to take control of this matter. Although the member for Port of Spain North also have a question to answer on the World GTL matter as well as other matters. Madam Speaker, they say that evidence from the arbitration was withheld from Petrotrin. The Prime Minister said this in his interview in the airport. He said, well, they're holding back evidence, the information from arbitration. What did you do? You are the government. What did you do to get the information, to get the documents from the arbitration to Petrotrin lawyers in this matter against Mr. Jones? You did nothing. And the reason you did nothing, because there was a political conspiracy to cover up this matter and to remove and withdraw the Malcolm Jones case from the High Court. That is why you did nothing. Madam Speaker, Madam Speaker, the timeline is there. The Attorney General says no files pass and so on. We have dealt with that. Then they come with $45 million paid in legal fees. Do you know, Madam Speaker, the magnitude of this matter? The weight of this matter? That 2 arbitrations dealing with this matter in Canada and the UK awarded legal fees of $39 million. So when you quote up and down the place $45 million in legal fees, 5 lawyers, in the arbitration they assess costs, legal fees on both arbitration was how much? Was $39 million. So, Madam Speaker, I hope they are not coming with that argument today about that. legal course and so on. Madam Speaker, the role of the Attorney General, and my motion speaks to it, Madam Speaker. This Attorney General knew, he was aware of the claim, that is clear. The Attorney General, by sitting with counsel and all counsel meeting on February 16th, inadvertently or not, and it was not inadvertent, gave instructions to attorneys to take the matter of Nelson advice to the Petrotrin Board. That advice had the effect of withdrawing the matter from the court. So he's guilty of that. In the public domain, there have been no assessment of the evidence, no issue. Madam Speaker, the Attorney General has displayed a complete lack of care of this particular matter, a lack of due diligence, a lack of disclosure. Madam Speaker, the Attorney General came to the Parliament, told us he has passed the papers to the Law Association, assuming the Law Association asked him for that. Today we are no better off because we have not been provided with any enlightenment by the Law Association on this matter as well. Madam Speaker, as a consequence of what I have announced here, as a consequence of what I have said, I will sum up to say that the Attorney General, the member for San Fernando West, acted as the closer on this matter. There's a show on TV called The Closer. He was the closer. He was identified by the party and the energy czars to close this matter, to bring it to conclusion, to remove it from the court. A mature, responsible Attorney General would have looked at this matter and indicated that given the gravity, given that one administration had initiated this matter, my administration is in place, let the court decide. Assuming but not admitting that the Attorney General is right, because the Attorney General has said he was in fear that the matter would fail at court. Assuming but not admitting he's right, then the matter would not have progressed much further in the court. The court would have thrown it out, and the Attorney General could have gone unscathed to the national community and say, the court, the Supreme Court, dealt with that matter, not me as a politician and as Attorney General of Trinidad and Tobago. They did not do that. They did not do that. Madam Speaker, he surrendered his responsibility to the public to assume the more comfortable role as defender of the political party. And I go back to Sir Robert Horne in my initial statement. When an Attorney General bows to the wishes of a political party, justice is destroyed. And on this matter, it is not to point fingers. We are not here to point fingers. They will stand up to say, well, what about Section 34? What about live sport? What about BTAM, this and so on? It is not here to do that. You promised better. When you came into government, you promised better. There is an expectation. There is an expectation that you would act better. So you don't come today, because their strategy is to blame their political inheritance for their failure. That is their strategy. They explain their failure by political inheritance. And that, Madam Speaker, ought not to be the approach. It is not to say I point one finger at you and you point 10 at me. It is not that at all. It's to explain the position why the member for Diego Martin West in September 2009 in an appropriation budget, a budget speech, would you believe the member for Diego Martin West, now Prime Minister, stood in the House and screamed about the cost escalation in this matter? So, Madam Speaker, today I want to indicate to you without straining the facts that enough has been said, enough has been shown to demonstrate that this Jones matter was withdrawn without proper consideration and with indecent haste, and the Attorney General could not adequately consider the facts and examine the documents. This House cannot contemplate in silence such a dereliction of a fundamental duty and cannot pass over without dire consequence an act for which we have described today. It strikes a most deadly blow at our respect for law and justice in this country. We have built a case to properly call for the resignation and or the removal of the Attorney General on this financial scandal. And Madam Speaker, I beg to move.
Member for Chaguanas West.
Thank you, Madam Speaker, after that scintillating performance, I beg to